Okay, good afternoon, everyone. I'd like to welcome all members and guests to the October 2nd, 2024 Public Hearing Committee meeting. And I'd like to remind everyone that our meetings are web streamed and televised. So if you could just take a moment to ensure your phones are on silent, that would be great. If anyone is attending virtually, please keep yourself muted, use your team hand raise feature icon, and turn your camera on when you're called upon. And with that, I'll call the October 2nd, 2024 Public Hearing Committee meeting to order. And roll call, Councillor Huffman, Michelle, and Vandendriessche send their regrets, but all other members of council are present today. Are there any disclosures of pecuniary interest? Seeing none, before we adopt and approve the agenda as presented, I'm going to turn the floor over to Mr. Sloan for some comments about today's agenda.
Yes, thank you. Good afternoon through the chair. So just a procedural note about both of the files at the Public Hearing Committee today, that it's come to our attention that the original notice for these had the typical Tuesday date for our PHC meetings. But given that our meeting today is on October 2nd and not the advertised October 1st, and although we did put up some notification of the date change and there may be minimal public interest in these two files, to ensure there's no technicality, we've now decided that there should be another statutory notice provided. So what we would suggest is that we'll proceed with introducing the items and some questions today, but we'll look for a deferral to bring both of the applications for a second public meeting on November 5th and then a decision thereafter.
Okay, with that, I'm looking for a motion to approve the agenda as presented. Moved by Councillor Columbus, seconded by Councillor Brunton. All in favor? Carried. I now officially open the public meetings held under the Municipal Act, the Planning Act, and County Policy. Please be advised that under the Ontario Planning Act, as amended by the province, only specified persons and public bodies as defined in the Planning Act may appeal a decision of Norfolk County to the Ontario Land Tribunal. Third parties or anyone who is not a specific person or public body do not have the right to appeal a decision to the Ontario Land Tribunal. However, to preserve the ability to be a party to any appeal to the Ontario Land Tribunal, third parties or general members of the public are required to make comments or provide written submissions. These meetings are being hosted to allow oral and written comments as input to the decisions on specific development applications. The first item we have is item 4.1, the zoning amendment for Birds Canada, which is report CD 24-124. I note that we have Stu here. Mary, are you here for this file as well? So just in an effort to save everyone's time, are you interested in staff giving the full presentation on the report today, knowing that we're going to come back in November, or would you like to skip that? You're more than welcome to speak to it today and in November, but if not, we don't need to do the full staff report today, given that there was an error with the...
I'll leave that decision up to staff. It's been suggested to me that it's better for me to speak today, but I will go with whatever staff recommends.
Okay, so from council's perspective, we will hear the full staff report in November. Are you okay with that? And we'll allow Mary and or Stu to speak today on the public record because they've come here? Okay. All right. I don't think we need the staff report from staff. We're going to hear it in November. Let's save everyone's time. And I'd like to invite Mary and or Stu up to speak to us. Whenever you're ready, Mary, you have 5 minutes.
Good afternoon, members of council. I'm pleased to be here today to ask that you consider an application to amend the official plan and to amend the zoning bylaw. In 1960, there was a Long Point Bird Observatory established at Long Point Tip. Because the lighthouse was there, there were facilities that were there that were no longer needed, and over time those became owned and used by the Bird Observatory. Over time, as water has risen and erosion has taken place, those buildings have become unstable, and they were right in the dynamic beach areas. So the proposal before you was to replace a non-conforming use. The issue being The details in the official plan and zoning bylaw about non-conforming uses are that they must be the same size or less and on the same footprint. So we can't do it on the same footprint and be safe. So what has been produced by Birds Canada, which it's now known as, is a replacement plan which would permit 3 or 4 accommodation buildings, just small ones that would be elevated in an area that's level and out of the dynamic beach, a research cabin, a storage cabin, and the current Jane Bowles cabin would continue. So we're not asking for the size or footprint in total that was there before. It's actually a smaller one that we've set out in the zoning bylaw. And this will permit the Bird Observatory to continue. It is world known. It's important for training ornithologists. It's important for other research. As Stu put it to me a few minutes ago, they study the whole ecology of Long Point, not just the birds. They also take away a lot of the trash that washes up there. They have been instrumental in keeping the Phragmites down. And so many different positive things have come out of them being there, besides the employment that they offer. And so with that, I would suggest to you that this is in fact a good proposal, that it's in the public interest, and that it's good planning. Thank you.
Thank you very much. Is there any questions, or are you happy to? Okay, Councillor Brunton, please.
Yes, thank you, Mayor Martin. Just briefly, did they stay overnight out there? I guess they would, eh? Excuse me.
Yes, they do. There's no more than 10 at a maximum that are out there. They try to keep the numbers down. But because birds fly at different times of the day, depending upon what types of birds they are and what the weather's like, the other logistical issue is it takes over an hour to get out there by boat and an hour to get back. So that's just not possible, not feasible to be transporting people daily, given the weather conditions as well.
Yeah, so these buildings have facilities for overnight stays?
Yes, they do.
Okay, thank you.
Councillor Columbus.
Thank you, Madam Mayor. Mary, I take it that the properties are assessed for property taxes out there?
The properties are owned by the province of Ontario. There's a memorandum of understanding that's issued by the Ministry of Natural Resources and Forestry to Bird Studies to be at the point.
So is the property actually owned by Birds Canada, or is it owned by the Ontario government?
It's owned by the Ontario government.
But the application is Birds Canada?
Yes.
Okay, yep, thanks.
Okay, Mary, I hope that, I apologize for the inconvenience, but I hope that you'll join us again in November in case there are other questions from council members that are absent, and we can get this file cleaned up at that point in time for you. My only question would be maybe a question for Stu, but through you. I would be very interested if you had a timeline and an ongoing estimate of the costs and fees associated with the work that you've been doing. If you could bring that to the November meeting that we could share with council, I think that'd be very insightful. Okay, thank you very much. Is there anyone on the line that wishes to speak to this item? Okay, seeing none, what we will do is defer the staff report, or defer the staff report to the November public hearing meeting, which is, which date? The 5th, I'm hearing. Tuesday the 5th. Is there a mover and a seconder to defer? Councillor Van Passen, question, comment?
Well, I will move it. I just question the reason for the deferral is to have it recirculated. Should that be in the motion?
Through the chair, we would be doing another notice for the November 5th date. So that notice has to go out, I think, in 2 weeks' time. So we're deferring it so that we can do a notice to have the correct date for the public hearing committee in case there is a member of the public interested in the item.
Yeah, so we need a reason, right? So it's
Deferral for additional public notification. Okay, moved by Counselor Van Pasten, seconded by Counselor Duthie. All in favor? That is carried. To be continued.
Madam Mayor, just,
yes.
the report indicates October 1st is the date, and it's actually the 2nd. That's probably where the original confusion came out on meeting times, yeah.
Correct. Thanks. Okay, the next item is item 4.2, the 2024 housekeeping bylaw, CD 24-125. This too will need to be sent to November. So are there any pressing questions that you'd like to pose to staff right now? Councillor Van Passen.
Not that quick on a computer, so you got to bear with me.
That's
here. So
okay. Take your time.
just a couple of questions on the proposed housekeeping changes. The first one is a change in the definition of farm operation. And the proposed is that it shall mean an agricultural activity carried on a farm by one person in the expectation of gain on one or more properties. But that's pretty specific. There are a lot of situations where the farming operation is carried out, like as an example, by a husband and wife, and that is two people, or I guess a corporation is classed as one person, but it's the partnership type of operations that will not be captured in this definition. So I was wondering if it should be changed to one or more persons.
So, Mr. Chair, we have a definition of person in the zoning bylaw, and that covers all those multiple person ownership and organizations, corporations that all cover within the definition of person.
Okay. Should make note of that. And the other one is on the, where are we here? The zone provisions to include a maximum lot size for residential lot surplus to farm operation. Now, in the first place, I don't know anywhere else in our zoning bylaw where we have a maximum lot size. We only have a minimum lot size. And I believe that the intent of this would be to try to protect as much of the actual cultivatable farmland that we can. You know, I've argued before that the minimum lot size used to be 1 hectare, and now that I think it's they want it to be half a hectare now. But these are surplus farm dwellings. They already exist. They are there. A lot of times, or most of the time, they are severed in a way that makes sense. And these houses are 50, 75, 100, 150 years old. They've been there a long time. Let's give our farmers a little bit of credit that they've been stewards for land for a long time. They built the house in like the least useful area of the farm in the first place 150 years ago. The old timers always told me that the way you built a house on a farm is first you dug the well, and where you found the water, that's where the house and the barn went. So there is a tendency that these surplus dwellings are set back farther from the road. It's awful hard to create a severance that's only going to be a half an acre and a hectare in size. A lot of times the applications come in, you know, where they're requesting the severance is sort of a natural break in the area, like there's already an existing tree line, or there's an outbuilding that they want to keep with it, you know, in the farm setback from the road. So it's awful hard to keep it down to the size of an acre. You know, I've seen applications be adjusted where, you know, they sever the driveway as a 20-foot wide piece, and then it bulges out in the middle of a concession to try to keep the area. So I don't think there is a need to implement a hard and fast rule that there is a maximum size on that severance. What we will end up with is just a whole lot more applications for minor variance to go beyond that, because, you know, the people requesting the severance will be trying to make the boundary look or make sense with on the ground. Maybe, you know, the suggestion would be some wording in our official plan and zoning bylaw that is more of a guideline, that the intent is to limit the size to affect the least amount of cultivatable land rather than, there's a map that says everything in Norfolk County is agricultural land, but not all of that is cultivatable land. And in my mind, there is a difference. We want to protect the cultivatable land, but not necessarily just the map that says it's all ag land. So I wonder if we can send that back to staff to dwell on those comments for me, please.
Sounds good. Councillor Columbus.
Councillor Van Passen has raised a very good point, and over the years, we've seen a lot of this where the building infrastructure on a farm property just may not fit under 1 acre. I think there was one just recently in my ward that came up for a discussion like that. And it'll make it a lot easier on the committee of adjustment to make a common sense decision, rather than what sometimes they have to go through to limit the size of a severance.
Sounds good. Okay. Then I would look for another mover and a seconder to defer this report to the November 5th Public Hearing Committee so that staff can put out another notification and consider some of the amendments and comments made today. Moved by Councillor Duthie, seconded by Councillor Berry. All in favor? That too is carried. So that is short and sweet today. I would look for a mover and a seconder for adjournment at, yes, sorry, go ahead, Councillor Breton.
Could I ask a couple of questions just on planning issue? I don't know if it's appropriate, but I'd like to, I'm curious as to the application we dealt with there a week ago in Norfolk and Decoux, and where it might end up at the Ontario Land Tribunal or whatever, if that's the case. But any concerns that we have with the intersection there, are they documented? Would if it comes back, do we still have a chance to deal with that intersection, or how is that handled?
You mean through the developer? Would you be able to?
Do we get another kick at the can, I guess, is that?
So probably the negotiations, or if a decision was made at OLT, he's wondering, do we get a say in the intersection?
So through the chair, at this point in time, I believe we're in the notice of decision for that application, so we're not aware of the next steps on where that might go. In an instance where there is an appeal to the OLT, then it becomes into their purview for making a decision. And there can be advice provided or legal advice provided to council as a party to any hearing that's made, and whether or not there is anything that happens. But essentially, the OLT can make decisions on a land use matter. They would not necessarily have jurisdiction to make decisions on an actual intersection, if that's the specific question about stoplights, turning lanes, etc. Those may be at subsequent stages if there is a land use approval given, and then if there is a subsequent site plan development, that's where you would get into some of those functional issues and decisions, which would be at the municipality level.
So his question is, I guess there's two hypotheticals here. One, if it goes off to OLT and OLT makes a decision granting some type of development there, does the municipality have any
Recourse.
discussion, or he's saying recourse, I would say sway over the intersection? And then the second hypothetical is they come back to us through a negotiation process through OLT. What role do we play?
So through the chair, that would partly be dependent upon the municipality's decision on what role the municipality would play within any OLT matter.
Yeah, the only reason I'm asking that is that whole proposal down there. If for whatever reason it does come back and it's approved to go ahead, the biggest cost is the intersection completely. I mean, at least in my mind, that's where a lot of substantial costs will come into the picture, either for us as a municipality or for the developer. And my concern is, I hope we have some say, that's all.
Maybe I guess I'd suggest through the chair and apologize for not being explicitly clear, but I would identify maybe for committee's benefit that next week on your agenda, there is a closed session report regarding OLT hearings update. And so there may be an opportunity
So just to be clear,
to provide an update.
I'm not hearing an answer about road work. If OLT makes a decision on planning and development, does OLT have say over the road? If one of the contingencies was a developer was going to do a traffic study and a road widening, if they go to the OLT, they may take that offer to do the traffic study and the road widening off the table. Does the Ontario Land Tribunal have the ability to tell a developer that they must widen the road?
Through the chair, we'll talk in general terms. So it will depend on what application is before them and then what authority they have to make the decision. So in the instance of an official plan amendment or a zoning bylaw amendment where there is a land use decision before the tribunal, they could authorize either to refuse that land use decision, they could approve that land use decision, it potentially could even go beyond what, in an instance where an applicant was willing to make concessions and alter, like add more setbacks and
I
add
want to
more
use
parking.
this specific example. If OLT approved that development, but did not offer to do road widening and did not offer to do a road traffic impact study at OLT, could the OLT add that in as a condition? Do they do that?
To the chair, road widening would not specifically be in the purview of the land use amendment. That would happen at the site plan stage, which is the municipality.
Okay.
The tribunal can't necessarily add conditions to a zoning because you can't have conditional zoning. They could add a holding provision that would require traffic studies and other things to the satisfaction of the municipality, though.
Okay, and then one more hypothetical here. If OLT approved that development as it came before us, and the developer did not offer to do the traffic study, they did not offer to do the road widening, by the time that development came to the planning department for site plan, are you still able to make that a condition, even though the development has technically been approved?
To the chair, if there was a scenario where the OLT made a decision on a land use and there was a subsequent site plan, or let's say subdivision, in this case site plan, the municipality would have the ability to require studies or apply conditions that are authorized under that section of the Planning Act. So traffic study would be able to do that. It's a little bit more at that stage to the functionality. So it wouldn't be looking at if there's too much traffic because of this land use, what do we do? But it would be looking at, hey, the land use is approved. How is the driveway access going to function?
So to that end, you could, through site plan, require the traffic study, but not require the road widening that was offered.
Well,
I believe road widening would still be through the site plan, correct, Mohammed?
Through Madam Mayor, the issue that the councillor raised is basically addressed during the site plan stage. It's not something that is identified. It can be identified, but generally it's not addressed through the official plan amendment and zoning bylaw amendment. So after, if it goes to OLT and if there is a decision come from the OLT to move forward, then these issues will be addressed through the site plan application. And we can provide conditions. And in our last council meeting, we talked about our engineering comments, which already identify some of those issues and also mentioned that those will be reviewed during the site plan stage. So the road widening, the road improvement, addition of pedestrian pathways or sidewalks, street lights, all these issues are site plan stage issues, and those will be reviewed, and if necessary, it will be under condition for the site plan approval.
so sorry, Madam Mayor, if I may, so you're saying that the OLT cannot just say we're going to grant approval and not require site plan? They can't come that far and say no site plan required, let them build the proposal as they laid out. Because when we dealt with it, we did indicate some of these issues, but I don't believe there's anything in that effect once it's turned down. We turned down the application, so I guess I'm a little leery. I mean, and I'll use this as an example. I still know that, take for example, Davis at Norfolk, just to change the lights, not the driving lanes, is over $300,000. So if we get up to redo that intersection, we could be looking at a substantial cost if it's not covered, I guess. That's my concern. So anyways.
Through Madam Mayor, if it goes to OLT, then it will be for official plan and zoning bylaws. So the appeal will not address the site plan issues, and this site is under site plan control. So eventually, whatever the decision is, I mean, if the decision is to move forward, they have to come for a site plan application. There's no way to go for the other way.
Thank you very much. I have one other question, if it's in order. Do we, I never see in our reports from planning development charges, like if that development went ahead, it's outside the urban boundary, or the downtown, I call it, and so there's a specific number of development charges that would apply to that particular development. It'd be nice to see that in future reports, how much funding might be available if it proceeds. So under the finance part of the report, we usually see that, but no figures. So
I think that's a very good point. Generally, the development charge depends on, if it is residential, depends on the number of beds. If we know at that point, we can identify what would be the development charge. Commercial, I think commercial might have a different calculation, but I think if we can identify those information, we can get those information.
I think, if I may, like if they say we're going to have 60 units in this particular facility, here's the amount of development charges that could be received as a result, something along that line. Thank you.
I think also that would be a really good subject to breach again when we go through the development charge bylaw, because we also have to keep in mind the competitive nature of other development charges from other municipalities around us. If we're going to put a price on development, I don't want to be chasing away or encouraging more than what we have planned for in our growth study if we start to estimate what those development charges are and then publicize that pretty heavily. I would want to be careful with that, but that's an interesting point. And at the risk of getting in trouble again, it is not outside of the urban boundary, but I know that's not what you meant. You meant outside of the downtown core. Okay, thanks for those questions and answers. Central Business District, correct, thank you. Okay, mover and a seconder for adjournment at 3:28 p.m. Moved by Councillor Breton, seconded by Councillor Columbus. All in favor? That is carried. Thanks very much, everyone.